okayfm 101.7.
Yenko Honorable Ekow Assafuah Mrenimuni Osan. Yeah, Honorable Memwache.
Yeah, but I do so.
Naboko dear.
No, I'm afraid no one. And then when your friend, Isaac friend, also Honorable Vincent. On friend, you did what's it? What's it? You didn't come up.
Is that so?
I don't know.
So him say, so when will be your young quo? Now could he Sabre no position a wadi no. That's only one munyam emano.
Yes.
I me kanewo minimum Gospel Center Assemblies of God. What my three abokanso. Aha, na ye fe kire wa ne abepie tafo ahimbronum wo to aso a medos na wo hoyi wo fa medos market ye chi a no wasi abobo na Roman a wo koyi wo ye ma servant nya ne susu ni be be na les kwadu etie ewo kire ho no wo wam se na ko nsonku
wo ye na ma so no wo so ni him wo de o fe ni a wo because life is busy.
Oh, ebe kama na mabawo nchen ya we dey wada wo ma menhwe wo dey asem court over the removal of the Chief Justice enura yesi court no ama ruling na ruling no net saying
well minya no kre and court, but they become a function from my out of consequences for Ghana for now. And now a court now, no, I could do court now above the non upper home base madu. Until no above non the master word you know. And the case said authorized. Until the man who should charges are ever. Ngosha, acting Chief Justice. Let me do more obey. Now say, oh, I said, someone, you try to first one, second one. Now acting TV in Campobi. Then I feel you know about the idea to them one. Also, it's training for the matter. So our first objection to the bench was that the CJ, though constitutionally is not barred from setting on the matter. So, the BNC who counsel better not so, and now counsel. New move the purpose more for purposes of appropriateness. For the fact that Rebecca said justice has not only been done, but justice has been seen to be done. It has appeared that justice has been done. And the acting PD. Transformer, if you say a seven, Mamina, you know, that's a suspended and no more be idea. And one way or the other, there is a certain interest into you have every power. So better as a vessel. No, and fatal. Induction home, it's not time for my. You can have a pencil that. What's it as a Robert Nassau? The court went into a conclave. Papa no say tintina ada and yes yake over no problem. Secondly, and yes I raise another objection that judges are not a much as so now you can fair no a day be kind any day to see me no that judges no I said when you mean self him. A day, yes, wow, come will be at the above the castle. And also to your if we say,
Baba, say, Mremunu, Onyan from Subia, is that the acting Chief Justice?
No question, though. As an officer of the court, it will be a lie to you if I say so. I am from so. For a Supreme Court judge to sit on a matter, this is CJ and as acting CJ, and I am panel. Into a whole point, so be and panel and also be constitute a panel to sit on the matter. But if you, every judge be judge, every painting be painted. And the judge win a chance and so would be a seven. We in the free or saying. A given I'm waiting a free home. It is a wood was a new year. What was some new year? Abiana as some more canning now your constitutional. Because I want my counsel. Nancy so big in a child because may have been a Nipami and sound would be shame woman. Tell Nipami and Sana Sona. Obabaka ya somewhere the buyer no in my counsel. So you see, you may have served justice, you may have done something constitutional, you may have done something legal, but where lies the morality of it? And then a bystander, ordinary Ghanaian. More share that you do a tenor you do, and yet a tentia. And I say, investors almost so. The one who finds so being invested or mining mono. That investors and also can say, hey, now, no matter what you as some of the cost of Chief Justice, she did that was a son of more than the call for about one back. But follows about the concept of Abitia. And you may not see the sort of confidence in the judicial system. It is on that basis that we made an argument that it will be proper. The acting CG, ever man judges and FCS and somebody can't answer back from you know, as an answer. Rather than bringing in a new panel. I don't see a kaya, Papa said that. Also, that's not a person. Now, and Kofu, you know, side of the come on a car on one man, why me and son. They will sit on the matter. Then we were helpless. Yes, it's what can I say? And a young boy answered so. As someone can say, and not court. It was on my interlocutory injunction as to whether the president's warrant of suspension with respect to the Chief Justice should stand or otherwise. It was my considered opinion. Say, the suspension of the Chief Justice should be suspended. However, Supreme Court, I say, you know what I say. And I'm saying, when you forward your moon court, Article 146. Article 146 of the Constitution, actually, if you say, open so you Chief Justice, the actual power, and yet Constitution, and they say, the President, in your petition, the next automatic step, according to 1466, and they say, Obe consulting the chief, Obe consulting the Council of State. But, since 1992, by 1992, no, not, you.
Me kwa me so Baston na me kenka constitution.
Me na me new me kwa me hu se me kan constitution. Me ni ma dia kwa fe ni ABC. The intent of the framers of the Constitution in 1992 no. I find se mu say we be Chief Justice they establish a prima facie. Kwame, Ewuza.
There be.
Aha. Kwame, say name. Obi the petition kosi any electoral commissioner. Jane Mensah. The patrol, our constitution, how an electoral commissioner will have to be removed. Kwame about the room.
The
whole constitution.
But Ebia, and yes, specifically written in black and white, but Ebia, what Sebia, Upeso Yibia, independent body being now Nunia, these are the steps.
Hey, Kwame, what be you?
Sir,
Kwame, I said, I'm the lawyer, James, so it's regretting you. Nothing. It has not been clearly stated, black and white, as you rightly said. And in fact, in the words of Henrietta, what do you call it? Mensah, who said the deputy AG that the fact that breakfast will have to be taken doesn't mean that if you have not eaten, then you take breakfast at 4 o'clock. Is it still breakfast? Kwame, constitution no, and maybe be a yaksho and ye be a juma. Because Supreme Court it's me at transfer as a way a unconstitutional. And maybe be a yaksho and ye because any muntino, you have find your juma. Kwame, in your own words, black and white. The Supreme Court, through Justice Colletti, had the occasion to say or ask my lawyer, say a judge in the world constitution more substantively. Interesting. Say, what person you chief justice? This is a change now. The first automatic step. They say, 1, for petition no comma CJ, and so now they are for a year council of state. What are the timelines in giving the CJ the petition for response?
No response no e be free president no and what they come CJ ni say or respond and now from the council of state and now abedu committee level. Which of them is that? Because all the altering pattern rule no actually say manipa ko no fair hearing. It's fair hearing no e be ko so hifa.
Come what they do and I make a choice say adia no nyina no constitution no enche. Minimum in the case of a JQ where case law is supposed to fill the lacunas in our constitution, and also in reading the constitution, the Emma and electoral commissioner, any constitution, minimum you're aware that if we say case law has affected us as to how we go about in removing an electoral commissioner. So there, in the constitution, you need to establish a prima facie before you would, as it were, go ahead with the processes of removing the chief justice. No, it is case law in the JQ that made us know that you need a prima facie. It is not stated in the constitution. It is on that basis that you catch Supreme Court judge say, Justice Colletti, with the greatest of respect, it needs not be stated in the constitution. However, it is our considered opinion that in reading the constitution purposively, that is the letter and the context of the constitution, and also in the words of Sowa GST in the 24 verses Attorney General, when it said that when you read the constitution, please do so by way of the letter and the spirit of the constitution. And in reading the constitution purposively, it is our considered opinion that the first automatic step after the president receives the petition is the president ferrying, transferring the petition to the CJ before any other step would be taken.
Now, Mami Musabi, there have been some commentaries. Our Moka say Article 146, and now say President, onye legal officer na onye adwuma wo sade na quasi legal decision no, it must be read, the article 146 must be read together with article 296. The 296 no kura de e ka say there shall, which is mandatory, ebenya regulations bi a ebe guide the process as enshrined in article 146. Ehono binum si there bi yenye in absence of that no, what do you mean ka say must be read together with article 296. Is a 296 yenye mre bia regulations bia regulating the conduct of removing the chief justice or otherwise per the 146 na edemayen. We know what you say law.
Well, okay, lawyers for a way of interpreting the constitution. They also have a way of understanding the constitution. And when it comes to issues of discretion, as you rightly said, the president or discretion be how is it supposed to be regulated? In my considered opinion, exercising your power of discretion, it will have to be done fairly. It will not have to be done capriciously, and it does not have to be done whimsically. It will have to be seen to be done in such a way that it will be fair. Other than that, it can be tested in the law court. Now, when it comes to as to whether regulations will have to be made in such circumstances, I am aligned with the school of thought that indeed, for such circumstances like this, where the president will have to, as it were, make a decision by exercising his discretion in suspending another arm of government, and emphasis my another arm of government, it will not have to be left in the hands of the president to just say that I have exercised my discretion this way without any proper regulations. And that is why I have had cause to maintain that when there is a procedural breach in how the Chief Justice will have to be removed, nothing can remedy it. Even when the Supreme Court said that President, or the Adiana Kwakuma Chief Justice Navy, so it has been remedied. That cannot be the case because when Timmy free back on policy, when Timmy free back on got 3, this will free 1 after Rock 2. So you cannot say that Adiana or say number 2. There is a question number 3 in the Indian. There is a procedural breach, there is a procedural impropriety, and same cannot be allowed to stand. And that is why I believe that the suspension of the Chief Justice will have to be suspended. And in fact, the ruling now, court in the 2 Supreme Court judges agreed with my position and said that yes, indeed, it will have to be suspended because there has been a procedural breach. And that is why Harriet Mensa said the breakfast who could do 4 o'clock is just a breakfast. It is not breakfast. So you cannot say that I have taken time not to eat. Then we could eat 4 o'clock. And to be eating 4 o'clock, that is my breakfast. No.
I see. Now, no. Will be some say, what are you crying more than the bereaved? Chief Justice, she's talking less. But what is the source of your motivation?
Pardon. The name is all Constitution one in China.
Maybe I told me be her.
And to the article 200 baby, radio boy. Yeah, what's here for?
Okay.
Not almost a while.
Okay. Article 2 of the 1992 Constitution.
Yes.
Yankin can be Article 2 or say a person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment, or B, any act or omission of any person is inconsistent with or in contravention of a provision of this constitution may bring an action in the Supreme Court for declaration to that effect.
Kwame, already we now there be a 1-2 and so come one.
2 they say
1-2.
1-2, okay. I take a 1 1-2.
Yes, Article 1.
This constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this constitution shall, to the extent of the inconsistency, be void.
Na who you ask 130 so can hold near we
130, okay. 130 no so say any or say asama watch on woni 130, okay. 130, okay. But your 130 no so asama watch on ho any or say you know a trust was say original jurisdiction of the Supreme Court, Article 130 clause 1, subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedom as provided in Article 33 of this Constitution. The Supreme Court shall have exclusive original jurisdiction in A, all matters relating to enforcement and interpretation of this Constitution.
The combined effect of this 130 and 2-1 and 1-2. SSM Ghana ni mapa. So we say be a course. Na say enforcing and I say interpreting the Constitution. I need not have a personal interest. I need not be a personal beneficiary, which has been stated in a number of line cases, that I do not have to get any interest or whatsoever before I can go to the Supreme Court. And in fact, the Deputy Attorney General sought to even question the constitutional right in doing so. All the 5 judges told him that he has no right to even question the plaintiff's interest or the plaintiff's constitutional right in coming to the court, because I have an inalienable right as a Ghanaian under the Constitution to enforce the Constitution of Ghana, to go to the Supreme Court when I think that some interpretation will have to be done, to be able to guide future actions and inactions of state actors. So, in fact, I need to be applauded for testing the law, for making sure that in future you know how to go about these things, especially when lacunas are in our Constitution. So it is not the case that I am crying more than the bereaved.
Okay. Now, my Musadia we per the 296 of the 1902 Constitution, said there must be some regulatory or regulations and act be to regulate the activities of the 146. You know, who Parliament be whatever over kose who rest be a promulgate these acts to, you know, guide future presidents in exercising the what is enshrined in the Article 146.
No, I think we can look at it. It is part of our democracy in making sure that we shape how our constitution is operating. I understand the bigger problem because of cyber, and that is why we've used case law and amendment in our constitution. The ones that do not have to go through a referendum, we can amend it in Parliament. We said citizenship in 1996. We can amend it in Parliament so that in future government and other future governments will have to be guided as to how some of these things will have to be done. I'm also praying the Constitutional Review Committee to also look at these matters and set it out clearly, so that you don't have a Supreme Court to tell you that at the end we are sure of Constitution in one, and knowing very well that our Constitution is a living organism in the words of Suwa GSC. it is a living organism. It grows, and when it grows, contemporary days, how things are supposed to be done and reflect is how the constitution will have to be interpreted. Into the constitution will grow beyond, necessary time. It's about 30 years and more, and so I think that it's something that we can test a year parliament.
Say, Ubako review and answer already.
I'm the idea of this.
Oh no, I think now I see them say you pumps on farm. Hey, now, see, 2 men be a show.
Come, brother,
maybe I'm a fellow. Maybe I'm a
fellow.
What? Isaac so appreciate. You and Ton shirt will yeah, we so Naya ko Naya ba. Na mami fa we
okayfm 101.7